Hello, I'm Chris Rokosh, and this is the second of a four-part series titled Legal Issues in Nursing, Empowering Nurses with Medical Legal Knowledge. It will be helpful for you to view these videos in order, as each one will build on the information presented in the one before. In this video, you will learn about the stages of a medical malpractice or nursing negligence lawsuit. Firstly, an alleged injury occurs. Medical malpractice lawsuits begin with an injury that is alleged to be caused by a physician, a nurse, or a healthcare professional. The patient or their family may lodge a complaint with the healthcare facility, which may result in full disclosure of the error, policy change, and an apology to the patient. Studies have shown that this type of response to complaints can help reduce litigation by as much as 40%. Alternatively, complaints are sometimes met with a denial of any wrongdoing, which can lead the patient and their family to seek the advice of a lawyer or to file complaints with professional regulatory bodies. Step 2. The patient seeks legal advice. The patient may choose to proceed with a medical malpractice lawsuit and seek the advice of a lawyer. The lawyer will review the case and may seek the opinion of expert nurses and doctors to determine two things. Were there any breaches in the standard of care? And did these breaches cause or contribute to an injury? The lawyer will then advise the patient whether or not they will represent them. At this stage of the lawsuit, they will also discuss potential costs and risks associated with litigation. The lawyer may request a retainer or a fee in order to act on the patient's behalf, and they will typically work on a contingency basis and only collect further money if and when the lawsuit is successful. Step 3. The statement of claim or notice is issued. If the lawyer and the plaintiff decide to proceed with the lawsuit, the proper steps must be taken to sue the doctors, nurses, and healthcare institutions involved. Legal documents, including one that is often called the statement of claim or statement of notice, must be issued with the court. The statement of claim will name the plaintiff, the defendant doctor, and the defendant hospital and nurses who have been accused of negligence. Remember that negligence is the failure to use such care as a reasonably prudent and careful person would have used under the same or similar circumstances. The statement of claim will outline the alleged injuries and facts which support the claim. The statement of claim will also outline the amount of damages or money the plaintiff is requesting as compensation for their injury. Copies of the claim will be issued with the courts and served upon the defendant doctors, nurses, and hospital. Note that a medical malpractice lawsuit must be filed within a certain period of time. This is known as the statute of limitations. It is usually within 1 to 2 years of the date of the injury. However, in special circumstances, as in an injury to a child or an infant, the limitation period does not expire until the child reaches the age of 18 or the age of majority. In cases involving injury to a person who is mentally incompetent, the statute of limitations may never expire. Step 4. The statement of defense is filed. In response to the statement of claim, the defendant doctor, nurses, hospital, and their lawyers will respond to the allegations by filing a legal document called the statement of defense. The statement of defense identifies whether the defendants admit or deny the facts and allegations as outlined against them in the statement of claim. Step 5. The medical records are reviewed. At any stage of the lawsuit, but often early on in the process, the lawyers will request copies of the medical records. These records may include doctor's office records, ambulance reports, inpatient and outpatient hospital or healthcare facility records, laboratory and diagnostic testing, records from community healthcare and rehabilitation providers, and pharmacy records. The medical records will be carefully reviewed by the lawyer and nursing and medical experts to assess and determine potential injuries and areas of nursing or medical negligence. Nursing documentation will be very carefully reviewed and used to recreate a detailed timeline of events. This is just one of the reasons why proper documentation of care is critical. Nursing documentation can provide evidence that the standard of care was met and has the potential to protect nurses from being found negligent or not. The medical records will also be relied on during the upcoming examinations for discovery, settlement, or trial. Number 6, expert opinions are obtained. At some point in the lawsuit, again often quite early in the process, the lawyers who represent the plaintiff, the doctors, and the nurses will consult with healthcare experts. The purpose of this consultation is to determine who had the duty or responsibility to provide care, whether or not the standards of care were met, and to identify if a breach in the standard of care caused or contributed to an injury. Expert reports will be obtained from both the plaintiff and defense lawyers and are often used to settle the case out of court. Number 7, examinations for discovery or deposition. Most lawsuits then proceed to deposition or examination for discovery. During this process, all of the parties involved in the lawsuit will be questioned under oath by the lawyers. The purpose of this questioning is to gather information, define and narrow the issues of the lawsuit, and decide how or if to proceed. Following discovery, some of the defendant doctors and nurses may be dropped or let out of the lawsuit if it is determined that they were not in any way responsible for the alleged injury. Depending on the information obtained, the lawsuit may then be dismissed or settled or proceed to trial. Number 8, the case is dismissed, mediated, settled, or proceeds to trial. If at any stage of the lawsuit it is determined that the medical malpractice case has no merit, the plaintiff's lawyer may choose or advise the plaintiff to drop the case. Alternatively, the plaintiff and defense lawyers may meet and settle the matter out of court. When a case is settled, there is no trial and no findings of negligence against the defendant doctors or nurses. The plaintiff will receive an undisclosed amount of money in compensation for their injuries, and it is frequently a condition of settlement that the details and the amount of money paid to them are not disclosed. If the lawyers cannot come to an agreement, the case may proceed to mediation to try to settle it. If mediation fails, the lawsuit may then proceed to trial. The plaintiff, the defendant nurses, the defendant doctors, and the experts who provided opinion may then be called to testify in court. Trial may take place several years after the lawsuit has commenced. It will take place in a public courtroom, and all evidence will be given under oath. The evidence may be heard, and the outcome of the case will be decided by a judge or a jury. This may lead to a judgment in favor of the defendant doctors and nurses, meaning that the patient loses the case, or it may lead to a judgment against the defendant doctors and nurses and result in an award of damages or money to the patient or the plaintiff. In this video, you have learned about the many stages of a medical malpractice lawsuit. These lawsuits can take several years to complete, and you may have absolutely no memory of the adverse event or the patient. This is only one of the many reasons that accurate documentation of your nursing care is so important.